You'll have a seat up on the witness stand. And please pull that microphone to you and adjust it so that it's your height that you can talk into. You'll state your name and spell your last name.
It's Morris Dawes Cooke Jr., and Cooke is C-O-O-K-E.
Thank you. Would you please tell the jury a little bit about yourself?
I'm a lawyer, practice in Charleston, South Carolina with firm Barnwell, Whaley, Patterson, and Helms. I've been doing it since graduated from law school in 1979, clerked for a judge for a year, and I've been with the same law firm since 1980. And I practice mainly civil litigation.
And do you primarily represent plaintiffs or defendants?
I don't mind representing plaintiffs, but most of the time I'm representing defendants.
All right. And do you know Alex Murdaugh?
I do.
How do you know him?
Through practice of law. I've had cases against him over the years.
Okay. And have you represented him before?
No. Well, I mean, now I do, but I did not previously
Right.
to this, right.
Right. What was the scope of your representation? for Alex?
I'm defending him in the boat accident case.
Okay. And when were you asked to join his team?
In December of 2020, I got a call from Danny Henderson and asked me if I would become involved. The case had already been going on for a year and a half or so at that time.
Okay. And did he have other attorneys representing him at that time?
Yes, yeah, the Hainsworth firm, John Tiller in particular, was representing him.
Okay. And what, if any, understanding did you have as to why you were asked to join the defense team?
Well, John was sick, as I think everybody knows now, and would be undergoing treatment from time to time, and he was unsure as to whether he'd be able to cover everything by himself. And so I was asked, one, to help him, sort of be a second chair for him, and also be a backup for times when he would not be able to participate.
Okay. And would you please describe for the jury your assessment of the merits of the claim against Alex in June of 2021?
Well, I think I was the one that coined the phrase negligent parenting that Mark mentioned during his testimony. The claim at that time was that Alec was responsible for the boat accident because he knew that Paul was using his brother's ID. And I mean, I didn't think that there was a claim in South Carolina law for that, so I sort of facetiously called it negligent parenting. So we felt that it was a defensible claim. I always sort of felt that lurking out there was going to be what's now negligent entrustment, that eventually they would allege negligence for having let him use the boat, which is the substance of the claim now. But even that, we always felt like it was a defensible claim. That I think the big picture that occurred to me was to hold him liable for that would be to hold him to a higher standard than any of the other parents of the other folks that were in the boat, which
Okay.
anybody who's raised kids knows that that can be difficult.
Okay. And what was your assessment as to Alex's financial exposure as a result of this case in June of 2021?
Well, it was unknown, and I'll have to say that was I didn't even really pay attention to that issue at the time. I think there was still a declaratory judgment action pending that was going to decide whether there was some additional insurance. I knew that the one policy was relatively limited. So I wouldn't have said that he had no personal exposure, but that was certainly not the focus of our attention at that time.
Right. And were there motions pending when you joined the case?
Yes, several motions pending. For some time, there had been a motion by Parkers to change venue. They wanted it out of Hampton and into Beaufort County, and there was also, they had made a motion to amend their answer to plead admiralty law, which would have some benefits over South Carolina law for the defense. And then there was this, there may have been some motions to compel discovery with Parkers. I don't really remember specifically, and I think in October of 2020, there had been a motion to compel the answers to interrogatories and motion and request to produce to Alec.
And have you reviewed that motion to compel?
Yes.
Okay. I'm gonna, I'll know on. Yeah, plaintiff's exhibit, not plaintiff, I'm sorry, State's Exhibit 402. All right, can you see that?
Yes.
Okay, great. And do you, this is just the first page, but do you recognize this as the motion?
That's the motion. And then I think attached to that were 2 sets of interrogatories and a set of requests to produce.
All right, so I'm gonna use the interrogatories. Would you just briefly explain to the jury what interrogatories and requests for production are?
Right, well, we call it discovery. The rules of civil procedure provide various means of obtaining information from the other side. So interrogatories is questions that you can ask, and then requests to produce are documents and other materials that you can require be provided.
And the supplemental ones that we're looking at right here, were those seeking financial information, Mr. Murdaugh?
Yes.
Okay. And the objections, if you'll, well, the answers right here to the interrogatories, and then the objection right here. Have you reviewed those?
Yes.
Okay. In your practice, are those common objections?
Right, that's, this was done before I was involved in the case, but those are the exact objections that I would have made. These financial discovery, it's sort of the plaintiff's lawyer's way of saying I'm really serious, and I'll call it intimidation, not in a pejorative way, but it's meant to really worry the defendants, and it's very common. And the typical response from the defendant would be just like this, and that is, we object, it's not relevant, you haven't gotten a judgment against us, you don't need to know how much money we have unless and until you do get a judgment. The comeback to that is, well, your net worth could be relevant on punitive damages. If it goes to the jury, a jury could consider your wealth as a factor in awarding punitive damages. And so 95% of the time you work out some agreement to provide a financial statement, but I would never have produced all of these details at this stage of litigation as a defense lawyer.
Okay. After joining the defense team, did you have meetings or communications with other members of the defense team?
Yes, regularly. And I have to admit, there's a lot I didn't remember, so I've gone back and I've looked at my emails, my time records. And we defense lawyers, we measure our lives in tenth of an hour increments, and we have to write everything down. So it was helpful for me to go back and look through my time records as well as emails to see who all was included. But yes.
Okay, and was Alex often CC'd on the emails?
Oh, yeah.
Okay. All right, did you ever participate in any Zoom meetings with the defense team?
Yes. The one well, there's more than one, but the first one I remember was April 15 of 2021. I was just sort of getting involved. I don't think I'd made a formal appearance in the case yet, but there was a Zoom conference. And I remember Alec was included on the Zoom invitation, but I honestly can't recall whether he was in the meeting itself. I remember others who were in the meeting.
Okay, and what was the purpose of that Zoom call?
It was really to kind of orient me, and also there were some motions scheduled in May. So it was just to get me oriented, talk about what the important issues in the case were and the things that we'd be focusing on.
Okay. And having attended that meeting, what, if any, understanding did you have as to the biggest issues facing Alex at the upcoming motions hearing?
Right, and I had to go back and look at my notes to refresh my memory on that, but it was the upcoming, as far as I was concerned, it was the venue issue, whether the case was going to be transferred back to Beaufort, because we didn't want it transferred back. We wanted it to stay in Hampton. We thought that the plaintiff wanted it to stay there too, but he was wavering, and there was some thought that he might consent, and we didn't want him to consent. So that was a big issue. And then we spent a lot of time talking about admiralty. You know, was it beneficial to have admiralty as opposed to state common law? So that was, as far as the hearing, that was the important part of the conversation. That was about a 2-hour meeting, and we talked a lot about experts, depositions that needed to be taken, and so forth as well.
And after that meeting, based on those conversations, what, if any, understanding did you have as to the level of concern the defense team had regarding the motion to compel the financial information?
Really none. I wasn't dealing with Mark directly on that. John Tiller was doing it, and as far as we were concerned, that was something that they were going to work out, but the focus on the hearings was going to be on these other substantive issues.
Did you ever have a concern that the motion to compel would be granted in total?
What's the question?
If he personally had expected the motion to compel to be granted?
Also 401 and 402.
I sustain the objection.
When was the motion to compel originally scheduled to be heard?
It was in May, I'm going to say May 10th, sometime in that area.
Okay. And did that go forward?
No, I think John, some of his treatment had to be rescheduled, and so they agreed to continue the hearing.
And when was it rescheduled for?
June, and I don't recall the exact date, but maybe the 10th or so.
Okay. And at any point prior to the motion to compel hearing that was scheduled, did anything change in terms of your understanding that would make you think the defense team was concerned about the motion to compel?
No, I filed my formal notice of appearance so that I could be at the hearing. I think I actually did that in May before the first hearing. And so I was prepared to be there to argue whatever needed to be argued. But as I go back and I look at my notes and my preparation, it was on the venue issue and the admiralty issue.
What, if any, factors did you consider when you made an assessment about Alex's personal financial exposure?
I mean, I never take a case lightly. I mean, Mark certainly is a very good lawyer, and obviously a very emotional case. So I won't say that we weren't concerned about it, but we knew that there had already been some other settlements, which we would have gotten credit for that. There were just a number of factors that made us feel like this was a defensible case and that it was not an existential threat to Alex.
Okay. Are you aware as to whether or not an order was eventually issued regarding the motion to compel?
Yes, what we call a Form 4 order was issued around October 7th or 8th of 2021.
Okay. What is your understanding of that order?
I've got it right here. I mean, it said that John Tiller had not been able to get the information and that, well, it says right here, the court at a hearing on plaintiff's motion to compel filed October 16, 2020 was informed that defendant's attorney Tiller, because of circumstances beyond his control, is unable to gather and provide the necessary information to answer the requested interrogatories at this time. Once this information is made available to attorney Tiller, the court will schedule a hearing on this motion to compel if necessary, which means that John Tiller was going to get the information, and then if he couldn't work it out with Mark, then they would have a hearing on the motion to compel.
So was it your understanding the court was ordering Alex to produce all of the financial information requested?
No, that's not what it said.
Okay. Me. just one or two more. Did you expect any cataclysmic event on June 10th regarding Alex having to give over financial documents?
No.
Okay. And do you recognize Mr. Tinsley? Do you know him?
Yep.
Do you see him here?
Yes.
Mr. Tinsley, can you stand up? Okay. Did you ever speak with him during the case?
Yes.
You did?
A number of
Okay.
times, yeah.
At all about the motion to compel?
No. Not that I remember. If he says I did, I couldn't deny it, but I don't remember it.
Okay, all right. Thank you.
Thank you.
By the state.
I think you said the motion is meant to really worry the defendants, right? Those were your exact words, wasn't it?
Could you repeat that?
You just testified that the motion to get those financial information is meant to really worry the defendants. Those are
Right.
your exact words, correct?
Always, yeah.
Okay. All right, and were you present at the trial lawyers conference when Alex Murdaugh came up and towered over Mark Tinsley and said, "What's up, Bo? What are you doing?"
No,
Were
I
you
don't
present
get,
at that?
I don't get invited to that one.
Okay. I didn't think you did. But you weren't there when that happened, were you?
No.
You were present for when he said that to that man right there about the boat case. "What you doing, Bo? What's up?"
I was not there.
Basis for the objection.
Foundation.
The objection is overruled.
And you did not.
Said he wasn't there.
Okay, thank you, Your Honor. All right. And you did not get, you didn't file your notice of appearance into this case until May of 2021, is that right?
I think that's about right, yeah.
Because you were actually representing other parties, and that had to be resolved before you could get involved with Alec, is that correct?
That's part of the reason our firm was, yeah.
Right, so you couldn't have been, with the conflict, heavily involved in any discussions that were going on between Mark Tinsley and John Tiller and Amy Bauer prior to moving into May, is that right?
That wasn't exactly the reason. The conflict had been waived, but I just wasn't involved in that. That was something John and Mark were handling.
Right, and when John, in May of 2021, asked for continuance of that hearing on which the motion to compel the financial information was part of, he didn't offer you as any sort of backup because you weren't fully on the defense team at that point, is that correct?
I think I had planned to notice my appearance before that hearing, and I can't recall whether I didn't do it because the case was continued, but I would have appeared at the hearing.
You were asked about insurance coverage, and you're talking about the Philadelphia policy, right? That there was a declaratory judgment action?
Right.
Right. And defense team knew that they weren't going to have any obligation to cover Alec in this, correct? I mean, it was very unlikely. In fact, it ultimately, Judge Sherry Lydon in the federal district court denied that Philadelphia had to cover Alec one penny, correct?
Yeah, I'll have to say, I wasn't following that, but that's pretty much my understanding. It was a long shot that there would be coverage.
And when you were at this point in time in May of June of 2021, just getting on the defense team, you certainly didn't know anything about his true financial condition, did you?
No,
You didn't know he'd been stealing money for years and years, did you?
no,
You didn't know that he was broke, did you?
no,
You didn't know he had misappropriated funds and was scrambling to try to replace those before people found out, did you?
no.
You were asked about the hearing on June 10th that ultimately was continued because of these terrible murders, correct?
Correct.
That's your understanding. The
That was
murders
my-
happened and that hearing got continued because, of course, who's going to have a hearing in the wake of these terrible events, correct?
Yeah, I think Mark agreed to continue the hearing.
course.
Right.
Yeah, that got continued, right?
Right.
And even as a civil defense attorney, even if you believe that a claim down the line may be defensible, that still doesn't change the discovery process in a civil case that goes on, correct?
That's true.
I mean, discovery still can happen and is going to happen.
Right.
Regardless of whether or not the case settles or goes to trial or whatever happens, correct?
Yeah, it's still going on.
And that's how civil cases, typically how cases work in court, is that both parties have to share a lot of information, and if one party doesn't want to share it, the other party can ask the judge to order it, correct?
That's right.
All right, and that goes on regardless of whether or not the claim is ultimately going to be successful. That's part of the initial process.
Right.
All right. And that was on the table for June 10th. That was one of the things that was on the table, correct?
The financial?
Yes.
Yeah, and there was the other interrogatories too.
And there was a
that they
number of
wanted
other
to answer.
things as well.
Right.
All right. And if that hearing had gone forward, there could have been an order issued compelling that process, correct?
Could have been.
Could have been.
Yeah.
All right. And so once that happened, once that order gets issued, that's going to set in motion a train that's going to have to come to a conclusion in a court of law, correct?
If that happened, right. Ultimately, the judge is going to decide what has to be produced and what doesn't.
That's right. Thank you, Mr. Cook.
Thanks.
Just a few. Mr. Waters just asked you for your opinion as to the June 10th hearing, and based on your 40 years of experience defending
I did not
cases.
ask for her for the opinion. I just asked what potentially could happen.
Let me hear the question.
Based on your 40 years of experience, what was your opinion of the likelihood that the order to compel would be granted?
Objection, Your Honor.
Let me ask you this. Just because it's possible that the order could have been granted, does that make it plausible?
Objection, Your Honor.
Sustained.
All right. Yes. If the judge had ordered the documents to be produced at the June 10th hearing, would Alec have had to turn them over immediately?
No.
That's all I have. Thank you.
And further.
If that had happened, it would have set in a process, set in motion a process, though, would it not have?
You're talking
Let me
about
rephrase that question.
If he'd ordered production of all the documents that were requested?
Right.
Yeah. That would have been part of the process, right?
It would have started a process, an order of a judge, correct?
That's true, yeah.
It would have happened eventually if the judge had ordered that, correct?
If he ordered production of all the documents, right.
Nothing further, thank you.
Step down.